Further hearing in the appeal James-Bowen and others against Commissioner of Police for the Metropolis.
Yes, Mr. Bowen.
Good morning, my lady, my lords. I got as far as YAP. I'm not going to go through YAP.
Yes. Yes, we left YAP hanging, didn't we?
I left YAP hanging, but I'm going to deal in a moment with some submissions on YAP. I'm not going to spend time going through it. It's a complicated case. We don't... forgive me, yes. I've emailed late last night, already this morning, you had an email speaking note. Yeah. I don't know whether that has reached you. We have hard copies.
Well, hard copies would be required.
So, I hope 5. And it's pretty much a script, so I will seek to follow it through. And we've endeavoured to answer some of the main questions that the court put to us yesterday, with the exception at the moment, I have to say, of the defamation question, which will probably come back to very briefly at the very end, or possibly after lunch. That's I hope to finish this morning. So I'm on, if you turn to page 10 of the speaking note, paragraph 15, and we don't believe, or at least hope there's no dispute on what then follows, that there's a relationship of trust and confidence which was plainly in existence between the appellant and the respondent, and that was, of course, one of the findings, or one of the conclusions of the Court of Appeal at MS 105, paragraph 33. It's accepted by Mr. Warnock that there is a relationship akin to employment. That's paragraph 25, MS 54. There was a remark from Her Ladyship yesterday that it's easy to get in, one would have thought, to trust and confidence. The big question, obviously, is scope. And we say that the finding of the Court of Appeal on the existence of the trust and confidence relationship, and also we say the controversial scope of the term itself, flows from the established principle that officers, even though technically not technically employees, are in a position which is really there's really no difference at all to employees who have a contract. That was dealt with by the Court of Appeal at paragraphs 29 to 30, and we see it in Milani. Milani is summarised at paragraph 5 of our written case, and there you see the references at subparagraph C. Now, all that was happening here, we suggest, is it was a restatement of what had been made clear in the White-Frost case, again, all the references at subparagraph D. In short, that the chief officer owes the ordinary officers the same duty of care which he would to an employee. That's Lord Hoffman 505C, which I think took you to. Now, there's bags of authority for this, we say, well-established proposition, all set out very nicely in the Mulaney case. Lord Justice Clark, paragraphs 44 to 52. And I would ask you to just, I'm going to try and turn up as little authority as only the really essential material. If you go now to volume 4, tab 39, and we can just quickly see the relevant parts of the analysis.
What's the page reference for Lord Justice Clark?
For Lord, MS 1480, paragraph 44 through to 1482. So it's essentially paragraph 44 through to paragraph 52. And if you just turn that up, you will see if you start at 46, first question which arises under this head is whether there's any relevant distinction between the duty owed by an employer to his employees and the duty owed by a chief officer to the police officers in his charge. My judgment, certainly considerations of public policy, there isn't. And then there's a reference to White. And White was, of course, all about psychiatric injury and whether there should be a differential between the protection available under the law to the psychiatric damage suffered by non-police officers as opposed to police officers. And it was held in these circumstances, it was held that the police officers should not be able to recover damages in circumstances in which others could not. That's one of the distributive justice points made by my learned friend. And then, 248, the incident case is not concerned with psychiatric injury. So Milani was accused of physical injury, a battle in a public lavatory between a gentleman and a police officer trying to arrest him. And what's said at paragraph 48, quoting Lord Gough, the 481 reference you see at, just for your note, MS Volume 2, MS 752 is the actual reference to the speech in Frost. That he would, for the present purposes, include in the category of an employee, a quasi-employee, such as a police officer, who, although he holds an office and is not therefore strictly an employee, is owed the same duty by his employer as an employee. It's true that Lord Gough dissented and would have dismissed the appeal, but there was no disagreement on the nature of the relationship between the Chief Constable and the relevant police officers. And Lord Stein at 497, and that is the relevant passages E to F, that it would be artificial to rest a judgment on the distinction between the duty of an employer on the one hand and the duty of a chief constable on the other, because the relationship between the police officers and the chief constable is closely analogous to a contract of employment. He said, therefore, that he was content to approach the problem as if there was an ordinary contract of employment between the parties. Lord Hoffman made a detailed speech of his own, but also said both that there was no dispute that a chief officer owes the same duty of care to his officers as he would owe to an employee, and that he agreed with Lord Stein. And then there's a reference to Waters, and then if we, and Lord Slynn, you see second and third line at paragraph 51 agreed, and then at 52, in all these circumstances, it is in my judgment now clear that the chief constable should be treated as owing to his officers the same duties as an employer owes to his employees, subject to such considerations of public policy as arise on the facts of a particular case. That proposition seems to me to be consistent not only with the authorities to which I referred, but also with principle. The relationship between a chief constable and his officer is so closely analogous to that between an employer and his employees as to make it just in principle to hold that he owes the same duty to his officers as an employee does to his employees. That has then back to the note at the top of page 11. I won't take you to any of this, but that's reiterated by Lord Reid at paragraph 47 of Robinson. The reference is there. And then all of the references, you've just got the specific references then to the passages that Lord Justice Clark referred to in Frost. They're just set out for your ease there between sub-Roman numeral 1 and 5, and also the reference to the Waters case. Now, if you look at just a little footnote at the beginning of our case at MS 65, you'll see here that the point that is made in terms of how in reality a police officer, the relationship is as heavily as can be analysed or can be described in a sort of contractual sense as much as a tortious sense, is the way that statute has intervened. And that's the point that's made at footnote 1, which is picked up second line of paragraph 5, the employment point I've just dealt with. Regulations have been made under section 50 of the Police Act. That's this is in your bundle at, I think, volume 2, tab 17. See the Police Act at tab 17, the regulations at tab 17. The Police Act are, not all of it, it's got, I think, quite a big, we can get anything you require, but the relevant point, which I can make swiftly, is these regulations contain exactly what you'd expect to see in a contract. And if you just look at the index, you can see Part 3 duty. There's some very detailed, and it becomes much more detailed in other parts of the scheme.
Well, what's the page reference?
Page reference, forgive me, MS 862 onwards is where you see the regulations.
Thank you.
And allowance and expenses, reckoning of service, and then determinations, Part 9. So these are determinations that the Home Office, the Home Secretary, will decide various issues which relate to the employment relationship between the Chief Constable, the Chief Officer, and the police officers. They'll make a determination. It might relate to pay or various other issues. And then, insofar as a particular police force is not following those determinations, that can then be enforced as a statutory tort, effectively, through I think, the county court. And it is really a design which is reflective of a contractual situation. It reflects very much the artificiality that Lord Steyn referred to in the passage we looked at in Milani, to show that there's really, you can put a tortious and a contractual position in sort of different silos when it comes to the relationship between the chief officer and the ordinary officer.
So is it the regulations that can be enforced or just the determinations?
I think it's, what's the, I'm told both.
Both. One would have expected that to be the case. Yeah. Where do we find that?
I'm sorry?
Where do we find that?
Where do you find that, did you say?
Where do we find the enforcement provisions?
Well, I'll have to count. I don't have that at my fingertips.
Well, somebody can let us know.
Yeah, but I'm sorry, that's right. So I'm now coming on and making a couple of points, and just one more point, sorry, before I go on to YAP. There are also, just so you are aware of their existence, deeming provisions in the employment legislation generally. Mm-hmm. So employment legislation that applies to ordinary contractual employees, when it comes to making sure that those statutory protections relate to police officers, there are deeming provisions, and there's an example there at MS 65, Section 42 of the Equality Act. So that's just another point to indicate what we say about these officers are enjoying the reality is they have contracts. So now I'm now at paragraph 16. I'm dealing with some points on YAP. This is set out at 14E of our written case, MS 69. YAP is an example of facts within the portmanteau where a breach of the trust and confidence term is found. You find it, I won't turn it up, but you find the point at little 2 at MS 1726, head note, paragraph 1 of the head note. There was an unfair and precipitous withdrawal from Mr. Yap's post as the High Commissioner of Belize. And it's important, we say, to remember that what was being dealt with here was a finding of a breach of contract entitling him to his economic losses. And you see that at paragraph 60 to 61, MS 1735. Now, Mr. Warnock took you to paragraph 120. You'll have that marked. I won't take you to it. The reference is 1743, MS 1743. And that's where Lord Justice Underhill appeared to raise some concerns about the interrelationship of the Malik term with the common law duty of care. Now, we say the explanation for that is what was going on in that case was an attempt to use the Malik term to outflank the restrictions on the Hatton restrictions on the recoverability of psychiatric damage in employment cases, or I should say also, and I think the Hatton, as I recall in Yap, those restrictions don't refer only to employment cases, but across the board. That's the ordinary phlegm point, the foreseeability, remoteness of damage point. Now,
You mean absolutely standard law of tort point?
yeah, well, yes, exactly. Well, and that's why all the references that Mr. Warnock took you for other reasons yesterday in White and Frost is that what was happening in White and Frost was they were trying to use a different implied term, the implied term about physical psychiatric safety, to outflank the ordinary rules of tort. And we say we are not doing that. And in our situation, I'm now top of page 12, tort and contract, we say, are entirely coterminous. So in our case, the accepted trust and confidence term derives from the quasi-contract. And we found, as did Lord Justice Moore-Bick, on the scope of that term, which then in turn informs the duty of care in tort. And what seems to be plain, on our understanding, is there are no tort rules restricting the duty that has been found here by the Court of Appeal. So I then move on to rely on, I won't take you to it, it was read to you yesterday, paragraph 19 of the Singh case. The absence of a recognised duty in tort does not prevent these officers relying on the recognised contractual term. And that, as we read it, is entirely consistent with Lord Justice Lewison's approach, where he rejected submissions which, as we read them, are very similar to that which Mr. Warnock is arguing for. Now,
I mean, what you really mean is that because if this were an employment context, the T&C term would exist in the present context, which isn't a contractual context, but quasi-employment. Yeah. There is a like tort duty.
yes, exactly. For our part, we apologise for not discovering Singh and Reading. We should have done, but the reason is, just in case you're curious why, we were searching for Malik, and that turned out that came under a search of Mahmood, because there were two cases, which is, I think, probably why on both sides of the bar we omitted that from our written cases. Stevens and Braganza were my other two paragraph 14 cases. Which we rely on just as further examples of the wide range of circumstances in which the portmanteau term has been applied. So then you see paragraph 18, we sum it up just in a few words. A wide term applies to a very wide range of situations in which there is a relationship of or akin to employment. It makes no difference whether the analysis is tortious or contractual, since the scope of the contractual term informs the scope of the postulated duty in tort, exactly the point my Lord Justice Mance just made. And then just reminding you of what my learned friend said at paragraph 49 of his speaking note. Paragraph 19, I'm afraid there's a typo there, it tails off, it should have read, as accepted at para 49, the police should not be treated differently from other employees. And then paragraph 49, his words are, Mr. Warnock's words are, police officers have a relationship akin to employment, and it's accepted it would be artificial to treat them differently in tort from other employees. But the lack of a contract in the case of office holders points to the scope of an employer's obligation to protect his employees, lying from harm in tort rather in contract. And that's, of course, where we depart from him, because we say you look at that implied term, you look at the policy, we'll come to this in a minute, you look at the policy behind that implied term, and then you transfer it, what I referred to yesterday as my sort of mirror point, and you transfer it into the tortious relationship. So that takes me on to proposition 2. The trust and confidence term encompasses the postulated duty. It's just another example of the general portmanteau, point I've already made, paragraph 20. And what we then do in the notes is we just look at what we submitted to the Court of Appeal and then what the Court of Appeal said in response. So first of all, we accept that he starts from the right positions, top of page 13, that an employer can really act in his own best interests unless he owes a duty to another party. That's last two lines of paragraph 31. And then the learned judge, having set out at paragraph 32 the trust and confidence term, he then sets out the submission that we made at the top of MS 105, and that really just reflects the Malik term. So, foot of 104, Mr. Bowen submitted that since the relationships between Commissioner and the officers was in substance the same as that between an employer and employee, that's paragraph 102 of the pleading, don't need to turn that up. A similar relationship of trust and confidence existed between them. Accordingly, he owed the officers an analogous duty of care, not without reasonable and proper cause, to act in a manner likely to destroy or seriously damage the relationship of confidence and trust between them. At any rate, when it was foreseeable that his actions might cause them psychiatric, economic, or reputational harm. And that's all set out there, you see, in the note, middle of the page. So we say that that submission was entirely consistent with the guidance that you've already seen. References there, third line of paragraph 22 of the note. Lord Nichols in Malik, already seen it, don't need to turn it up. And what was happening there in Malik was the court was dealing with a novel case, because of course it was the whole essence of the claim was to extend it into new territory, whether or not stigma damages could be obtained as a result of BCCI having run a corrupt business. The bank were under an implied obligation to its employees not to run such a business. And then it spelt out that the implied obligation is no more than one particular aspect of the portmanteau, a general obligation not to engage in conduct likely to undermine trust and confidence required if the employment relationship is to continue. And then Lord Nichols rejected a submission that the trust-destroying conduct had to be targeted either at an individual or a group. And he then tells us that it can be undermined in several different ways. And then quoting from just above 35C on MS 658, this is Lord Nichols, I can see no justification for the law giving the employee a remedy if the unjustified trust-destroying conduct occurs in some ways, but refusing a remedy if it occurs in others. So the focus here appears to be on the behaviour. It's conduct which has to impinge on the relationship, so it has to be during the currency of the employment relationship. You look at it objectively, or in the sense that looked at objectively, it is likely to destroy or seriously damage the degree of trust and confidence the employee is reasonably entitled to have in his employer. And we say then, applying what we say are those principles to our set of facts, that rather than take the uncertain and rather diffuse policy approach where we get to under issue 2 if you're not attracted by our submissions on issue 1, we say the following really is the proper analysis. The conduct here was targeted at the officers. Objectively, for all of the reasons I went into yesterday, there was trust-destructive behaviour. No reason...
Well, what do you mean by targeted at? I mean, you're not suggesting that the Met was out to get the officers. The Met was in a dilemma, wasn't it?
Well, we don't go that far, but this was...
targeted at and does mean, in the ordinary sense, deliberately aimed at.
Well, it's not, as I understand what Lord Nichols is saying in Malik, it's not, you don't need a sort of misfeasant, malicious act. You've just got to know objectively, looking at all of the circumstances, that the way that you're conducting yourself as an employer is likely to have a very serious effect on an individual.
Yes, well, one can understand that. Indeed, I mean, for my part, your submissions don't seem to be aiming at what this case is about at the moment. I mean, this case isn't about whether there's a quasi-employment relationship or a duty in tort in ordinary situations. On the contrary, that's admitted. If you look at the appellant's case and their speaking note, it's all about whether, in this context, that duty can exist and continue.
Well, that's really issue 2.
Oh, I know it is, but I mean, you're spending an amazing amount of time on issue 1, which appears to me to be common ground. Indeed, as you said, when you were going through the quasi-employment point, you said there doesn't appear to be any dispute about. We don't believe there's any dispute on this. Well, I think you're absolutely right.
Well, the reason I'll move on quickly, but the reason we're doing that is we say that we are within territory, we're within the term. So we're within the term, following Robinson and the re-explanation of Caparo. We don't have to go through the policy questions, which one only goes to if you're into the incremental process, and then you're bringing in a process which really has been, I'm not sure what devalued is the right word.
Whether the term exists in a particular context is usually helpfully illuminated by past authority, but it's pointed out that there isn't any, and so we're arguing about a novel situation on one view. It's just because somebody has expressed in one context a general proposition doesn't mean, say, the general proposition applies in every conceivable different context. Cases are facts.
Well, you have my submission, my Lord, which is that you look at the conduct and you look at the nature of the trust-destroying.
Yes, it's all about that, and you ignore the context.
Well, no, we're not ignoring the context. We are looking. I'll come on in a moment to. I mean, I'll finish up with this as quickly as I can, but I really need to take you through this.
But following on what Lord Manser said, the implied duty going both ways of trust and confidence is very easy to understand in dealings between the employer and the employee directly. But where you've got a third party involved, where you've got the employer having to possibly negotiate a contract with a third party, which isn't the situation, then it may be more difficult to consider the implied duty of trust and confidence to the employee. Now, in our case, the third party is different. It's somebody suing the employer. And I do think, following on from what Lord Manser said, that we've got to grapple with whether it is as easy to import this duty of trust and confidence in these third-party situations, Mr. Bowen.
Yeah, and I will come to that.
Thank you.
I will come to that.
Well, in fact, what we're interested in is the content of a duty, whether in tort or in contract or quasi-contract. That is the interesting question. And either way, it would be a development from the existing state of the law. It doesn't matter whether we call it a Caparo development or whether we call it a further development of the content of the implied term. That's what we're on about, and that's why we're trying to press you to get to the point.
I understand that. I understand that. We then go to Eastwood, where Lord Steyne discusses Gogay, looks at the distinction between the manner of the dismissal and then cases such as Gogay, where the continuation of the employment contract is contemplated. We say it's the same position here. Then you can see what we say at 23C. It was suggested that by Mr. Ward that Gogay and McCabe were cases of positive action by an employee directed to the very continuance of the employment contract, i.e. getting rid of the employee. Now, we say that's not the case. We say our case is really more than analogous to. It's the same example of what was happening in cases like Gogay, Yap, and McCabe. So if you then, paragraph 24 I don't need to deal with, I've just dealt with that point about the incremental approach post-Robinson. And then paragraph 25, we say you look at the Samco approach. And if we then look just briefly at Greenway and Johnson at volume 1, tab 7, 636. There's a short passage.
It's known as Dryden and Johnson Matthey in this court.
Ah, okay.
And judgment will be given week after next.
Right. And the passage
May not have anything to do with the point for which you want
right. Well, the,
to raise it. I'm not giving you any hostages to fortune. I'm just telling you.
the passage that I won't go through the whole of it, but it's 636 over to 637, and it's applying the guidance given by Lord Hoffman in the Bank Brussels case. And if you look at just above letter C, in the case of an implied contractual duty, the nature and extent of the liability is defined by the term which the law implies. As in the case of any implied term, the process is one of construction of the agreement as a whole in its commercial setting. And then, skip the next sentence, the scope of the duty in the sense of the, oh no, sorry, we don't need to go there. Then if you go down then to what Mr. Justice Jay found, which is the reasoning is agreed. If you flick over to the top line of 37, you'll see Lord Justice Sales agreed with the next sentence.
But that was all about the construction of a written agreement. And Samco's all about the construction.
Well, no, it's in relation to an implied term. In my judgment, in circumstances where the law imposes an implied term, in view of the relationship between the parties, essentially for reasons of policy, and that implied term is in substance the same as the tortious obligation, which arises for exactly the same reasons, it seems obvious that the exercise embodies a consideration of the scope of the rule or principle of public policy which creates or impresses the duty. And this we deal with in paragraph 17 to 18 of our case. And the essential point that we make there is that the implied term is reflected by the policy underpinning it, now very familiar, protecting the employee from trust-destructive behaviour. And it's satisfied on our facts because of the public condemnation followed by the internal and external exoneration via the disciplinary process. Therefore, we are within the scope of the term. That is a contractual analysis. We are in the area of the law of tort. So if you, I don't need to turn this up, but you'll be very familiar, obviously, with Caparo. Type of damage, is the type of damage within the scope? No issue on this aspect. Well established that pecuniary loss can flow from reputational damage. And then we've got the references there from Malik and Spring, volume 1. Volume 1, tab 8, 52F to H, MS 675. The majority considered that if the reference had been given while the plaintiff was still employed, his claim could have been brought in contract. On that hypothesis, he could have sued in contract for damage to his reputation. And then just below G, provided that a relevant breach of contract can be established and the requirements of causation, remoteness and mitigation can be satisfied, there is no good reason why in the field of employment law, recovery of financial loss in respect of damage to reputation caused by breach of contract is necessarily excluded. And then we see exactly, or we then see also volume 4, a similar point being made in the Spring case. So all of that supports, we say, Lord Bick's conclusions at paragraph 36. And then I just break down the term. It doesn't, there's a primary duty. Mr. Warnock took you through all of this. It doesn't necessarily cut across it. There was a mutuality of interest, that's top of page 17. No inevitable conflict of interest arose, therefore arguable that the Commissioner owed a duty to take reasonable care not to sacrifice interests and reputation unless there was justification. That's the next bullet point. That's a question of fact. So we're going no further than the scope of what has already been established. I know I entirely take on board what your lordships have said to me, but applying it consistently to quasi-employees, there's no difference or discrimination between the duties owed, no principal difference in the nature of the relationship. Next point, it's not a giant leap, and there's no reason, we say, that it should not apply to conduct of litigation, and I'll come on to that in a moment. Conceptually, no different to applying the term to, and then we've got our paragraph 14 cases. So summing it up, established category, little a, little b, entirely taking on board what my Lord Wilson said, we say that despite the fact that there is a third party suing, it's not, in substance no different really to what was going on in the disciplinary and suspension cases. No reason in principle why the term cannot incorporate trust-destructive behaviour which centres on the abortive defence of a civil action brought by a third party against the employer for the misconduct of the employee. So if that is so, and if it's within the implied trust and confidence term, if an employee with a contract of employment was in that situation, should these facts ever arise, and these facts are, we suggest, fairly exceptional in terms of the internal exoneration and the external condemnation, that an employee would be able to rely on the term. And point D I've already made. So no room therefore for and I'll whip through this, for Caparo Lim 3. We accept that at the time we conceded that it was a novel case in the Court of Appeal. So having looked at it in much more detail, that's why we have constructed issue 1 as we have endeavoured to do. The Singh case, we say, gives us substantial support in terms of what Lord Justice Lewison found, rejecting the argument that the fact that it was the problem, the trust and confidence problem emerged in the conduct of litigation made any, somehow negated a potential duty. So, and the point I made about it being a fairly rare beast is at paragraph 34. 35, whilst there may be cases where an employer, for commercial reasons, will want to settle, it will usually be done without a public admission of liability, either payment with no admission or a confidential settlement.
Mr. Bowen, the destruction of the trust and confidence can arise in two different contexts, as this case illustrates.
Yep.
First, it may be a consequence of a direct action by the employer towards the employee, or, as in this case, so far from it being targeted, as you suggest, at the respondents, it's an incidental effect of the litigation which the Commissioner was defending. Now, concentrating on those two different species of case, is there a difference of approach required in deciding whether the latter species, comes within the concept?
You mean the latter approach being the targeted?
No, the latter approach being the incidental effect of direct action by the Commissioner in relation to the claim that had been made against him.
Well, we say plainly the former case comes within the term, the targeted approach. What your Lordship has called the incidental approach, it's a bit more than incidental, we say, because on the facts of our case.
Well, however you describe it, what I want to get at is there a difference in the approach that one should take to the two types of case in order to decide whether the trust and confidence has been destroyed?
No, it's a question of objectively looking at all the circumstances of the case.
So it doesn't matter.
And it seems to me it doesn't
species.
matter. Yeah.
All right, thank you.
Yeah. So if I can skip the rest of page 19, going to page 20 now. And this is reasonable and proper cause from 42 onwards. If the behaviour is likely to have been destructive of trust and confidence or seriously damaged the terms engaged, question then, is there a breach? And as I think we've already submitted there at 43, you can see that even if objectively the behaviour had, rather than was dreadful, had an impact on the dreadful impact on the employee, provided it was reasonable and proper, there's no breach of the term, and therefore no breach of the duty. The test on breach you see at paragraph 41 of YAP, don't need to go there. Was the behaviour, the impugned decision, outside the range of reasonable responses? That's a question for trial, paragraph 45. And then if we're wrong about this, then we put them in the note, both there, page 20, 21, and you see it again repeated at 22 and 23. The incremental approach now so familiar and re-explained in Robinson. So that takes us on to proposition 4. Small incremental step. All you need is to expand slightly, if you're against us on issue 1, where the law has been thus far. The process, as I say, is well established, and that takes us on to proposition 5, which are policy reasons supporting that small step, and the first relates to conflict. And
just before we go to 5,
yeah.
Let's not go to the authorities, but if the requisite exercise is to build on other cases,
yeah.
What would be the particular other cases which you would invite us to build upon?
On the cases at paragraph 14, cases like the paragraph 14 cases, the Gogay case, the Yat case, I think the Deadman case, and they're all pithily summarised.
Your 7 cases.
Paragraph 14 of our written case at probably got MS.
Very well.
And I think you said earlier,
MS 69.
you earlier drew attention to, in particular, Gogay, Yap and McCabe as being the employer's reaction to a third party's complaint.
Yes.
Although obviously those were reactions directed at the employee rather than the settlement of a case.
Yeah.
But I think those were the ones that you drew particular attention to
Yes.
as
Yes.
indicating it's not a big leap.
Yeah, and also I think we'll get there when I get to the relevant proposition in my in our structure. an answer to one of the questions that your ladyship put to us yesterday about, well, what happens if two employees fall out with each other? Well, that's paragraph 12 of Deadman. And there's an investigation, and the employer simply takes a view. And once they take the view, as long as it's within the band of rational responses, paragraph 60 to 61 of YAP, then there can't be there's no suggestion that there would then be a breach. But what our argument does is it would just cast the protection of this, as I understand the academic analysis of this area, and the growth of an implied term which has been universally welcomed. And we use it as the only way to, as far as we can see in this case, which is Lord Justice Moore-Bick's position, to bring sort of some practical justice to these officers by reason of our only entry point now, having argued but lost the points on retainer and assumption of responsibility, has to be founded on the implied term.
Thank you. I'm sorry I interrupted you.
No.
Proposition 5.
So Proposition 5, Court of Appeal, we say, are right on this point, and there you see again the reference to the relevant part of the judgment, paragraph 36, delineating a duty into the primary duty to act in the interests of the police force, and the subsidiary or normally parallel consistent duty not to sacrifice the officer's interests without good reason. And we say that that is a good example of, and I'm just taking here from the authorities we haven't looked at but are referred to under Proposition 4, the sort of analogical and incremental thinking that the reasoning process now calls for. I think that's a quote from Lord Mance in one of the cases. The appellant argues, paragraph 18 of their case, that a potential conflict is enough. We say that there is no such principle. Certainly you can't extract any wide principle from the cases, that there can't be conflicting duties owed by the same person to different people. In fact, the reports appear to, the cases we've seen appear to in fact state the converse. Paragraph 22 of our written case, we say, we accept entirely there is potential for a divergence of interests between the parties to this appeal, but that isn't always the case. And here, there was a community of interest to defend the claim being brought by Mr. Ahmed. They only diverged as a result of the various failures by the lawyers and by the officers dealing with the defence of the claim. So it's by determining the scope of the duty that the court can then establish if they can run concurrently and whether the risk of divergence is sufficient to justify all the denial of any remedy to an employee. Cited in support of that are Gogay, which we've looked at, Berkshire, and the ABC case. The next section of the note, 25, and halfway down 26, I've dealt with. That's the facts of Gogay. But just to reiterate some of the Gogay points, so Milady said in that case, sufficiently egregious conduct on the facts there, the allegation of sexual abuse, equally to be accused of what these officers were accused of, and to have it confirmed and published is just as bad, if not worse. They passed the test. Was there reasonable proper cause? No in Gogay, no here. A potential conflict did not negate the duty in Gogay. That's exactly what was found by Lord Justice Bick at paragraph 36. And then that takes us on to D. Facts of D you're well acquainted with, and we seek to sum them up there at paragraph 57. The case against us is the potential conflict is enough. Paragraph 14 of Mr. Warnock's case, or paragraph 14 and 18. We essentially make 2 points in response. Doctors owe legal duties to more than one person, employer and patient. Paragraph 86 of Lord Nicol. The duty of care in that case was rejected not only because of the potential for conflict, but because of 2 points. The pernicious nature of child sexual abuse, the fact that it was a major social problem, a major social evil. And in the light...
The result would have been the same whether it was child sexual abuse or ordinary sexual abuse. Ordinary child abuse. In D.
Correct.
Yeah.
Yeah.
So it's not explained by the egregious nature of
Well, it was...
the particular problem of that. It's explained by other factors.
And because of that, in the light of, and this was predominantly Lord Brown, in the light of the inherent difficulties in diagnosis, if a duty had existed, there was a danger of affecting the mind or the decision of the doctor. So really a defensiveness point, danger of defensive conduct, but redressed in the clothes of conflict. But we say, if you look more deeply into the judgments, there are other points, and it's plain that you cannot, from that case, a far starker case, I think, to quote something said by the court yesterday, there is no support for a general rule that conflict equals negation of duty.
Well, I mean, one looks at the statements, but there is a statement, for example, page 421 or EMS 563 at F by Lord Brown.
Give that again, 563?
563 at F.
Yeah. Sorry, the point I'm...
Well, you said that conflict of interest could be really discounted as a relevant factor, but Lord Brown is saying here that ordinarily, when considering the imposition of a duty of care previously unrecognised by the law, the courts are astute not to create a conflict of interest. So there is some authority. Yeah. I think there's a similar passage in Lord Rogers' judgment or speech.
Yeah. But all we're saying is that in that case, it was there was a long analysis from Lord Nichols earlier on about the countervailing interests, the section really from paragraph 70 onwards, where he sets out the countervailing interests and the between interfering unnecessarily in family life and child protection. And balancing all of that up, and even though there's some reference, the Dorset Yacht reference to doctors probably being made of sterner stuff, because of the risk, because it was such a major problem, because of the risk that it might have put some form of cloud or doubt in the mind of those who are carrying out the investigation of what is criminal activity, that this was a case where a potential conflict would make a difference. So we're just seeking to put it in its proper context. So certainly no wide rule. And then we move on, and I can whip through this through to the ABC case. This is another good example in a medical context of the rejection of a submission that conflicting duties owed to more than one person as a reason for refusing to impose a duty of care. And that was in the context of whether or not confidentiality should be breached in relation to the father of a daughter. The father in this case had murdered the mother. He was either in prison or in secure accommodation under a Section 37 order. And the question was the extent to which they should override his refusal to inform his daughter he actually had Huntington's disease. And there was an attempt to, I think, to strike out, and the essential point in the case, as per D, was that that the fact that there was a risk of conflict at the top of page 29 might add some pressure to the doctor was insufficient to avoid what is otherwise a duty of care in the law of tort. So then we reach our conclusions on conflict. And this is a summation of what we say at paragraph 26 of our case. Given, and this is the distinction between our case and D, in D, it was the investigation itself where there was a risk that the decision itself might be affected by the potential conflict. Here we've had that investigation, and we've had an exoneration, and we have a full alignment of interest in terms of defending the civil action. Second point, no reasonable either public interest or private interest in terms of the employment context, which required the public admission of liability that occurred in this case, where that was set against the background that I've explained and the conclusion that there was no liability. So it can't in this case be sensibly suggested that from the beginning the parties were inevitably going to be in a conflictual situation.
That point 2 is essentially a factual point, isn't it? And it may not be agreed. The fact that somebody has been acquitted in disciplinary proceedings, where presumably the high standard of civil proof, or possibly even expressly the criminal standard was applied, but certainly a standard commensurate with the seriousness of the offences would be, doesn't point the answer to civil proceedings where there's no evidence available. And so I think that is essentially a factual point.
Well, just very briefly on that point, the disciplinary proceedings, as I explained yesterday, related only to one of about, 20 or 30 more allegations against one of the 4 officers. All the 3 other officers were completely exonerated from the beginning. And there was after the intensive investigation, and that was the IPCC. It was such it became a very political, high-profile case, and there was a sort of call for action that somebody should be held accountable for this supposed outrage that happened, which of course our clients say was never an outrage, was just a legitimate exercise of their public duty as police officers. So. So I think I got to little 3. So little 4. If the appellant had concluded that there was liability or some new evidence had become available following an internal investigation, the D and Berkshire stage, which suggested liability, the appellant then would have had reasonable cause to settle the litigation and make those admissions. And there would be reasonable and proper cause. There would be no complaint at law available for the officers. So then a key point then that we then developed at 4 is the point at which the conflict emerged. The point at which the conflict emerged and the parties' interests diverge is when we say the duty ceases. I think I've already might well have dealt with 5. This is the concern about potentially conflicting duties being owed to different employees. That's dealt with during the investigation, a consideration of all the evidence, a conclusion that may or may not be within the YAP, paragraph 60-61 band of reasonable responses. And they can deal differentially with employees according to their own conclusions. Consistent, as I've said, with Deadman, paragraph 12. And that was a consideration of the application of the trust and confidence term dealing with personal disputes and difficulties between employees. And there you see the reference. There was the manifest shipping point is at 6. That was raised yesterday by Lord Justice Mance. what happens where you have the scenario of an insurer refusing to pay to defend a case. We've had a quick look at that case. We don't see a problem, and our answer, it's very simple and straightforward. You either accept it or you don't, at little a, little b. If that happened, then the insurer decided to refuse to provide cover under the policy, there would be a reasonable and proper cause not to defend the claim. And in any event, in this case, the MPS, as we understand it, self-insure, so there's no third party. Doesn't make sense, the next bit. But so they self-insure. So the insurer will reach a view themselves on the strength of the case, take a decision, and that would be entirely legitimate. That takes us to contribution. And you can see the references there where it's dealt with in the respective cases. We don't add very much on this, only that the statute again gives rise to a potential conflict, as already explained in my last section. That does not negate the duty. The broad rule asserted, we say, doesn't exist. Point at paragraph 18b of their case, we say again with respect, is a bad one. And what Mr. Warnock is saying there is at the outset, when the employer begins to investigate, that they would have to automatically notify a potential claim. We say that such automatic notification would not be necessary, as once the conflict emerges, assuming there's a good reason, the employer, as found by the learned judge below, can act in his own interests and against that of the employee, and we spell that out at 27b of our case. It was said at paragraph 17 of the appellant's written case that this Part 20, bringing in the officers, happens quite regularly. As far as we know, having communicated with the Police Federation, that the Mohadeen case is the first and only use, certainly as far as the Met are concerned, of the Part 20 contribution proceedings. And then the fourth point, in the event that the Metropolitan Police did use Part 20 proceedings, such a use would also be consistent with the implied duty, since one, provided they'd been given a warning that their interests were no longer aligned, they would then, as a result of the Part 20 process, have an opportunity to defend allegations made against them. So it may be that the employer had decided to defend the case and then decided not to settle. But at some stage during the litigation, they could, of course, at any stage seek to pass on the liability to the officers. And we say that would be an entirely appropriate situation. We then come on to our next sub-proposition, which is the reputational issue, the extent of the actual and potential reputational damage to the respondents. And we say that that damage points very strongly towards the recognition of the duty. We suggest that the appellant hasn't really engaged either significantly or at all with this point. The fact that reputational damage has occurred, we say, is incontrovertible. Equally incontrovertible is the fact that the postulated term, in the context of, in precisely this context, the failure to defend litigation without good cause, is capable of causing the damage, point I've already made, psychiatric, reputational, and economic. The authority for that, we deal with this in our case at paragraph 29 to 30, MS 77 to 79. and we got I don't need to turn these up, we got the Willers case, and the Crawford case, and the Kuadja case. And those are cases where there was absolutely no doubt that very severe reputational damage can occur as a result of proceedings in court. And I just emphasize, I think 27D of the case at MS 78, where my Lords Lord Kerr and Wilson, in their dissenting judgments, referred to increasing judicial and extrajudicial concerns regarding the effect of the publication of an arrest upon the reputational, social, emotional, and even physical aspects of an innocent person's family and private life, particularly where that person has had no opportunity to address in public the widespread belief as to their guilt. And we say, really, that's effectively what's happened here. That's certainly what the officers feel. The next type of case where you see the same reputational impact are the cases where it's been discussed, Spring and Malik. I don't need to turn them up, but if I could just explain the MS references there. In Spring, 1591 is Lord Lowry, referring to how people can be irretrievably blighted by a bad reference. And then 1600 is Lord Slynn saying, it may well be there's no chance ever of getting another job. And a very similar point made by Lord Wolfe materially affects the chances of alternative employment. And then the point we make at 67.3.
But you're not actually saying that's the fact in this case. Of course, it's not been investigated, has it? But
Well, that's a question of fact.
exactly, it's a question of fact. So we don't know one way or the other.
Well, the officers certainly say they do know. I mean, they have remained in the force. This all happened in an awfully long time ago. This happened in 2003. 15 years on, they're still police constables. They say their promotion prospects have been irredeemably blighted. They despite their complete exoneration, they were never suspended. They remained even after the consent order and the public outcry, the brouhaha, the 1 month in Southwark Crown Court. They remained on the beat. Some of them remained, I think, on the Royal Protection Squad. Some of them had, I think, tickets for firearms. Yet these were gratuitous thugs, according to the admissions. I mean, the position was, it was just a bizarre situation that occurred.
Paradoxically, this big issue, a pure point of law about the existence of a duty of care, with all these decisions from Mr. Justice Jay and upwards, these judgments will actually, funnily enough, have served to vindicate their reputations to some extent.
Well, not really, because the imbroglio point that he makes is entirely contingent upon the fact it's a strikeout, and we have there are a whole series of non-admissions by the police because they say they can refer to LPP. There is no public acknowledgement. I think there's been no apology by the force. I mean, these officers believe that they have been treated disgracefully by the Metropolitan Police, which is why, after so long, this litigation is still in progress.
Yes?
And I know that I irritated the court somewhat yesterday by spending a little too long on the facts, but that was maybe perhaps one of the reasons why I did it. Going back, where was I? Getting back to my note at page 32. So paragraph 32, that's paragraph 32 of our written case. So in the present case, consistent authority to support the proposition that policy strongly supports protecting an employee from damage, the type of damage we've referred to, and then it's set out, as a result of the unfair conduct of litigation and or without good cause, and where the employer publicly admits liability for egregious behaviour where it's all been previously dismissed and discarded. And then at paragraph 33, MS 79, we see Lord Kerr making what now is a familiar point in the jurisprudence, that principle is to be preferred to reliance on uncertain policy factors, and that the use of policy in this area without an evidential base is hazardous. That's Crawford, paragraph 94, MS 422, which is why we have taken our principled stand on issue 1, and I know that I've received a fair degree of flack from your lordships in relation to that, but I bravely stood by it, and we say, whatever your preliminary views and your desire to get to the bit that we're now on, issue 1 is a very serious point, which really needs to be, which obviously, forgive me, which obviously will be considered. So that takes me to the end of the reputational point. Then we get to no insurmountable practical issues or problems arising from the postulated duty. That's covered mainly on paper. We have nothing to add on the point about settlement. On the point of not being able to criticise for fear of legal process, as paragraph 20D of the appellant's case, we have 2 points in response. And they'll be familiar now. If there is reasonable and proper cause, they can say what they like. They have no risk of liability. They're subject only to the laws of defamation, and they can say anything they want, as long as they've carried out a proper investigation and it is compliant with YAP, reasonable bands of response, 60 to 61. Which is the second point at paragraph 2. Paragraph 69, we put this in because this is an answer to a question from one of your lordships. During the appellant's submissions, it was suggested that upon receipt of a claim, an employer would not know what to do and whether to defend or whether not to defend. And we say that following receipt of the letter of claim, it's the same point really, there will be an investigation. A view will be taken. It'll be taken on the evidence. An informed decision will be made about whether or not they're going to defend. That's the same as the manifest shipping point. And then there can be no complaint. Inherent uncertainty of litigation is another point, paragraph 70. The answer to that, we say, is that in considering whether the employer has breached its duty, the court's consideration as to whether it had a reasonable and proper cause to justify the action taken, again, it's all the same point. Inherent uncertainties, that we accept entirely that things happen. We'll see in a minute. I put it in a different policy concern, but there was a concern about a witness, for instance, a witness not coming up to proof. That's an inherent. We don't know that that's going to happen. They decide to defend the litigation. They stand behind the officer, and then they discover something further down the line. Well, they pull the plug on it. They settle it. But they can only do that if there is some reasonable material on which to do it in order to get into the saving inherent within the implied term. That takes me on to privilege. I'm making pretty reasonable progress here. The essential points are that there is joint or common interests in existence between the parties, and I'll explain why in a moment. The joint or common interest gives, that joint, that community of interest gives rise to common interest privilege or joint interest privilege. You need to look at that. We've got you the whole section of Phipson, which is, I don't have the, I'll tell you where it is in a moment, which sets out the law. There's quite a lot of authority in this area, and we've got Barker and Mander are the two main cases. They're all noted up fairly extensively in the written cases. But we are, common interest privilege can either be used as a sword or a shield. Now, we are concerned only with that common interest being used as a sword to enable us to get disclosure. It enables us to raise the matters in the pleading and also to entitle us to various documents, which the other side say are covered by legal professional privilege.
So do you say that you can get all the details of the advice which they receive relating to the settlement?
Yeah, as long as at the time the common interest existed.
Well, are you saying it did?
It did. And I'm just coming on to that now. So, and I know the answer to the question, I think you asked me a question yesterday, Lord, about special factors. The special factor is the close quasi-contractual relationship, the community of interest, the fact that these men weren't just witnesses. They were to use another word, they were the target of the litigation. It was,
if a contribution notice had been issued at the outset of the proceedings, would the position have been different?
it would have been.
Yes, I think.
Yeah, because there would then have been a plain conflict of interest from the beginning. So there would be no problem there. So,
well, when did it become? Did you say it never became apparent?
I'm sorry?
Do you say it never became apparent that there was a conflict of interest here?
Until the 19th of February, 19th of February 20. Was it? 09. That's right. Yeah, the conference, the first conference with Mr. Jeremy Johnson. March, 10th of March, I think, 2008, those were the conversations upon which we substantially founded our case for retainer and an assumption of responsibility. We'll stand behind you. We covered all this yesterday. Not going to pay a terrorist off, alleged terrorist off, etc. A long shopping list of what the DPS, the Directorate of, DLS, the Directorate of Legal Services had to do. Get the notebooks, get our ARVs, I think they're called. You need the CCTV when we got out of the van. You need to proof officer A, B, C, D, and E. It was a whole list of, they were telling them what they needed to do. It wasn't done. I covered this yesterday. It wasn't done for the reasons I said yesterday. They didn't think the case would fight for two reasons, that it would either settle or he would be extradited. It was only 1 year later, 3 weeks and about 5 or 6 days before the trial, that they said, I'm terribly sorry, chaps. We are no longer going to act for you, is the pleaded allegation. We've got problems evidentially. He's not accepted the offers. And the words attributed to Detective Sergeant Nicholas Westwood 3 weeks before the trial was, they are now rushing to prepare the defence. The officers were horrified, particularly in circumstances where everything had been debated earlier. A point I should also correct is that the question about special measures came actually from the Met, I've been instructed. It was the Met who said, don't worry, we will provide you with special measures, to which the officers said in response, that's brilliant, we've already had our identity negligently or improperly revealed. We want our physical features. We don't want to be recognized. And they said, okay, if that's not possible, we will not expect you to give evidence. They were being very supportive at that stage. But an application wasn't made for many, many months. And the officers were only told that the application had failed barely a month before the trial. The position of the officers then was, you must make another application, to which the response from the lawyers was, there's no point because it'll fail for legal reasons. That went down badly with the officers, who then said, well, we balanced it up, and the day or two before the hearing, they came to the very reluctant conclusion that they couldn't voluntarily, having asked the Met to sort out all the issues. If you can sort out the issues, you can get everything together. So we have confidence in our legal team. Then we will expose ourselves to the risk that we'll be taken out of the evidential chain. But that never happened. So these men turn up to Paddington Green, they wait to be subpoenaed, it doesn't happen. So that's the story. So the answer to my Lord Mance's question about surely the conflict emerged at the very beginning is, I'm afraid, an emphatic no, it didn't. It emerged at the very end. And that's one of the things that makes this case so dreadful as far as the officers are concerned. I'll get back now to privilege. The Phipson reference, I don't intend to go to it, is tab 56, MS 1904. And what is a point that's made there is that the sword cases reveal no common thread of reasoning. So the law in this area is unclear. Second bullet point of paragraph 72. Some of them turn on the existence factually of a common interest, or sufficient common or joint interest. And for that, we've got Barker. And could we just turn up Barker? I mean, it's referred to in the written case at paragraph 42, 43. It's at volume 3, tab 22. And the section that we thought was particularly helpful was the top of the right-hand column.
Could we have a page reference, please?
Oh, forgive me. MS 1030. And this was a commercial case. You see the facts all set out at 1013. And the issue that arose was whether or not one of the parties, I think there was a joint, there was an oil case, there was there had been a joint venture which had been then terminated in subsequent litigation. I think the litigation had involved both of them, both Barker and Wimpey, defending against a common enemy. And then subsequently a dispute arose between Barker and Wimpey. And the relevant parties at the top of 1030. In fact, I should tell you that the section on privilege, no, sorry, I'm getting confused with Manda. So top of 1030, as regards the claim for legal professional privilege, it seems to me that the general principle underlying several authorities to which our attention has been called by Mr. Lincoln can be accurately stated in quite broad terms. I would put it in this way: if A and B have a common interest in litigation against C, and if at that point there is no dispute between A and B, and then if subsequently A and B fall out and litigate between themselves, and the litigation against C is relevant to the disputes between A and B, then in the litigation between A and B, neither A and B can claim legal professional privilege, the documents which came into existence in relation to the earlier litigation against C.
As I understand, this is all in the context of parties. A and B were both parties to the litigation against C.
I think that's...
I think not.
Not. Well, that's why I'm asking.
I think what happens, they were joint venturers,
Yep.
and they both had an interest, financial interest, and they were both entitled to share in the proceeds of the litigation against C. But I think, if I recall, that one of them agreed to conduct the litigation against C on behalf of both of them.
Yeah, we'll find the answer.
I think that's...
Thank you.
We ought to check it, but that's my recollection. I haven't read it recently. just have a look.
But I think like Junior will find that out on the computer, and we'll provide you
Well,
with
it's quite important, isn't it?
with the answer. So that's an analogous, in a precisely analogous situation here.
Well, it isn't, is it? I mean, it's rather important to analyse it. You can't. The litigation wasn't against your clients, and nor were they pursuing litigation against anyone. Your clients were simply witnesses.
Well, no. I mean, with respect, no. I say that would be an artificial distinction to make, because they could very easily. That it would be wrong, I think, for this to turn on the decision of the claimant lawyers as to whether or not to bring in the officers personally themselves, which clearly they could have done. But they didn't need to do that because of Section 88 of the Police Act and vicarious.
In which case, if they'd done that, as you've already conceded, they would be entitled to legal professional privilege.
Well,
You've already conceded that if they'd issued a contribution notice at the beginning.
Well, no. This is, they would both have been defendants defending the same claim. There's a different point. The point I conceded, milady, was if a contribution notice qua defendant, so use the old language, third-party proceedings. If the police had brought in the officers, then yes, I concede there's a.
Well, that's what I was putting.
But I'm dealing with a different point, which is that the claimants, Barbara Ahmed's lawyers, could have sued the officers. They could and should. They could have.
Yeah, they could have done, but they didn't.
But they didn't.
They clearly, if they then joined together to defend the claim, that might be a different thing. The Barker, what I said appears to be correct. If you look at 1018. 1018 MS, bottom left, section 1015, they had a written agreement governing the situation. As an essential part of this agreement, Wimpey and Barker agree that Wimpey and Gulf Marine shall press with vigour claims for changes and extras and additional remuneration arising from the work performed under the Aramco contracts, and to render each to the other such assistance as is necessary, etc., etc. And then they were going to share the proceeds, I think. And then Wimpey concluded a settlement with Aramco, effectively on behalf of both of them, as you see, which was complained about, I think. Penultimate paragraph on the right on 1018. At an earlier stage in the negotiations being conducted primarily by Wimpey's with Aramco on the disputed claims arising out of the DLW contracts, etc., etc. So it appears to be a joint venture.
Yeah. Well, and equally, there is a sort of analogous joint venture here between the public duty of the police to protect everybody from threats, a public safety point, and then the TSG officers who have the job of going out and making sure that it's done. And if the claimant lawyers had decided to join these officers as defendants 2 to 5, then of course there would have been a joint retainer. The solicitors would have acted for all of the defendants. There wouldn't have been a problem. It was only the decision not to join them in which enables Mr. Warnock's clients to be able to take this stand and then to say, well, we're not going to reveal actually the extent of our failures. One can be fairly sure that if, in this case, everything had happened, everything was hunky-dory and they had a reasonable and proper cause to justify their failure to take steps in the litigation, they would have waived privilege, which we see time and time again in police cases. But it didn't happen here. And it doesn't take much imagination to guess why it didn't happen.
Well, that's not a legitimate submission, is it? Okay. You're asking us to infer contents of privilege from the non-disclosure.
I haven't seen it. We've seen nothing, but we make inferences as to why that was the case. But the key point is the mutuality of interest and the fact that it would be wrong, we say, with respect to explain the status of these men as pure witnesses. They're looking at the reputational material we've looked at, and the case is under my, well, it's page 32 of the 65 through to 67 of the note. That puts this case into a different category. And it's a category where there is a sufficient joint or common interest, which enables the officers to then utilize that as a sword to obtain the material and to then have an answer to the suggestion that they can't even venture in the pleading into the areas of what happened when and why things went wrong. So that's the second bullet point of paragraph 72. So moving on, the third bullet, we have others are premised on a contractual relationship which is said to be inconsistent with a claim to privilege. And that's the Manda case set out at 44A of our written case. And could I just ask you to turn that up? That's MS 1031. In fact, it's the next one. And the part that I'd like to take you to is 1037. Left-hand column.
This is a neat description of Barker.
Yeah, so this is Barker. So in fact, we've been here.
I mean, isn't this commercial union and Manda case is readily understandable. If you agree to follow the settlements as a reinsurer, it'd be bizarre if you couldn't actually understand what the settlements are about. In other words, you have put yourself in the same boat as the original insurers, and you're bound by their settlements. You clearly have the commonest of interests. It's isn't that the explanation of the case? It may help you, it may not, but I just say that it's a simple case.
Well, yes, but when you've got in an employer-employee relationship with a mutual sort of mirror parallel, not parallel, a complementary obligation of fidelity and good faith on behalf of the worker or the servant, and the implied duty that the master owes. And they're all, prior to the emergence of the conflict, they're all very much in the same boat. And that's, I entirely accept that these privilege cases are commercial cases, and one can find distinguishing features. But we derive from them and the analysis in Phipson, which is set out in the written case, that our joint interest, which I think I said yesterday, is not a pure question of law, it's plainly a question of fact. And that's why whether or not there is a joint interest or not is something that is not really proper for a strikeout, which is why it was adjourned. We went through that yesterday, and I think I had some difficult questions from your lordships, which I hope I've now dealt with. So we've got the quasi-contract, there's foot of page 34, nature of the relationship, which encompasses the postulated duty. We need the documents in order for to establish the duty. So if we're right about the scope of the implied term, this is top of 35 now, applying in the conduct of litigation, such a term would be inconsistent with the employer being able to assert legal professional privilege against the employee, and then crucially, until the point where the interests diverge. And at that stage, LPP comes in. So, and it may well be that I've covered the rest of it, but the fact that the Director of Legal Services and Counsel have been found to act for the police alone does not prevent a joint interest or a common interest privilege existing. We've got the reference there to Phipson. So the point is, because there is no retainer, it does not affect the existence of common interest privilege. In order to obtain the legal advice, we need to go back to Manda for this, via joint interest or common interest privilege. That mutuality, the common interest, must exist at the time the advice was given. That's Manda 644, middle of the right-hand column. So 644, sorry, the MS reference being 1035. It's the big paragraph, penultimate paragraph, starting Mr. Gaisman or Gassman.
Gaisman.
Okay, sorry?
He was my pupil.
Well, I'm sure he's made some...
Progress since then.
A lot.
My mastery of Manda isn't enough to know whether his submissions were accepted or rejected. So you can see his submission. And then it's the section that begins, the sentence that begins, the right to obtain disclosure must, he submitted, arise from a relationship existing between the parties at the time the advice is sought. And insofar as it was extended in formica or formica, that wasn't accepted by the courts. So we say at the time the advice was given, in this case, there was always a sufficient interest. And then the next point, if and when they fall out, paragraph 40 of our written case, that doesn't matter either. That does not affect the existence of common interest privilege. Final point, potential conflict does not therefore defeat a claim to use joint interest or common interest privilege. Then we get on to distributive justice. And I can deal with this fairly rapidly. Submitted at paragraph 32 of Mr. Warnock's case, MS 56, that holding the employer responsible for trust-destroying and unjustified, we say, behaviour of causing reputational damage, just because it was in the context of litigation, would offend against the ordinary person's notion of distributive justice. And then they quote White-Frost in support. We say then, paragraph 75, we submit that it would be wrong to look at this case through the lens only of distributive justice as the more compelling call for reasons, the reputational points we've already addressed.
Can I just, before you go on, can I just direct your attention to Mr. Justice Jay's paragraph 60 on...
Sorry, could you just bear with me?
E131.
Yeah.
This is dealing with the question of retainer, but it might be of some present relevance.
Paragraph
60.
16.
60. He says in the middle of the paragraph, no such retainer, and then he says there were no affairs which the claimants were reasonably entrusting to the safeguarding of the defendant. Claimants had no direct interest in the litigation. In my judgment, there might well have been consequential, I think he means the fact that there might well have been consequential impacts on their reputations is insufficient to create such an interest in the sense of constituting a matter which the defendant was required by legal obligation to have regard to and or promote and or safeguard. And then he says there's no factor pleaded to amount to the necessary reliance, and in reality none plausibly exists. That's reliance on the conduct of the litigation. So does that bear on your submission that there was here a common interest from the outset? And that you were...
No, my lord, no. He's dealing there with a voluntary assumption of responsibility. If you look at...
yes, I accept that, but I mean... I accept he's dealing with a different subject, but he's making some findings about the facts, isn't he?
Well, he is, and it's something, that was his view. It wasn't a view shared by the Court of Appeal. The Court of Appeal plainly took the...
Well, they didn't. Did they address privilege at the Court of Appeal?
Well, this, with respect, paragraph 60 is not being said in relation to privilege.
No, I just wondered whether,
So,
did they
no,
address
didn't.
this point?
Well, subject to correction, no, they didn't. No, common interest privilege was studiously avoided by everybody up until this court.
But my
When you
Lord-
say studiously avoided, do you mean deliberately avoided?
It was deliberately avoided in the sense that a direction was charted very deliberately by the judge, saying, I don't want to look at common interest privilege because I don't need to. We were all fairly relieved because it's rather.
But that was
area
the
that we were
specific
familiar
claim, was it? And we looked
Sorry?
at that was the specific claim to see documents, which we looked at in.
Well, no, that was the claim to disclosure, which I can't now recall whether it had actually been issued at that stage, was the sort of parallel or response to the application by the police to strike out various aspects of the claim. So they say, as part and parcel of their application notice to strike out, I think second limb of it was, not only is there no reasonable ground to proceed in this case, no reasonable cause of action, and summary judgment. What's more, a lot of what you said you can't say is illegitimate because it's covered by LPP. To which the judge says, from my memory, subject to correction, we don't need to embroil ourselves with common interest privilege. There's enough in this case to deal with the main point, which I will now proceed to deal with, so we dealt with it. So to that extent, it was deliberate. It wasn't a sort of, it wasn't an evil plan hatched between myself and Mr. Beggs in terms of not dealing with a relevant issue, my lady.
Lord Mance's point to you is this, surely. Although this was said in a different context, the judge made findings which are pertinent to the question of privilege, aren't they?
He can't have made findings, it was a strikeout.
I know it's a different context.
and-
That's the premise of the question, that it was made in a different context. But are the findings not relevant to the question of privilege?
Well, exactly. Then I'm very grateful that they're not relevant because he heard no evidence and he was addressing what was entirely a question of law and something, of course, which can't have been, the Court of Appeal did not have joined common cause with him in relation to paragraph 60 because they found that there was, that the duty existed and there must therefore have been sufficient damage to complete the cause of action in tort. So that's...
How easy would it be in these cases for a court to identify the point where the interests diverge? Is it practical to think of a court being able sensibly to conduct that inquiry?
Yes. Yes, I mean, it's no different to... It's something which is entirely within... it's exactly what courts of justice do. And if the...
Funnily enough, I mean, you might need to see the documents in order to decide whether the point had come by then where the interests diverged. And so it's, it's circular. Because it's only if the interests have not diverged that one's entitled to see the documents.
The decision about whether the interests have diverged or not is primarily, it's a decision for the employer. and I mean, I've dealt with, and then there's the...
For the employer? I thought it would be a decision for the court.
Well, no, in the first instance, it's for the employer, and then subsequently, of course, if when one gets to litigate this issue, if the duty of care is found by this court to exist, then of course your lordship is right. Then it's a question for the judge.
Yes, thank you.
So I was moving on to distributive justice. I got to paragraph 75. So we submit that this case is really as much about or more about corrective justice and the principles behind distributive justice, which, as we understand it, relate to the fair distribution of burdens, risks and losses throughout society. So there are certain things that we all as a community have to share the risk of. One example I thought of from the Hill cases that we have all been involved in is Lord Diplock's famous, we haven't got it for you, but you'll be familiar with it, that the society as a whole run the risk of being the victims of crime. And the failed sterilisation cases, McFarland, which we hope to get to you, but we had a printing failure this morning. You'll be familiar with it. If you want hard copies, we can provide it, but it's very easily available on the machines. That was another example of the impossibility of carrying out the balance between the joy that a healthy child brings and the cost of bringing up the unplanned child. And then we've got White and Frost, just as understandable, because it was not fair or just to compensate the police officers at Hillsborough for the trauma that they suffered when the close family members were denied compensation, the Alcock rules, the secondary victim rules, in very similar and far worse circumstances. So we say to understand the true role of distributive justice, you need to look at, and forgive me, we're not going to take you to any of this, but we'll just provide the material if you want more material on, to be reminded of what the courts have said in the past. And Milady certainly, I'm sure, won't, because Parkinson is one of your cases, as I recall. And we will also get for you the extract from Clark and Linsell, which sets all this out very, very clearly. A point that Milady made in Parkinson in relation to the distributive justice argument and what judges, particularly Lord Hoffman, said about the man on the London Underground or the woman on the Clapham omnibus, is that it's not really that helpful to ask that question because it so much depends on what they're told or what question, how the question is put. So accordingly, just sort of stating, well, most people would be very surprised if there is a differential in treatment between these, what Mr. Warnock calls witness officers, and other witnesses in the context of litigation. I say is a very small point and doesn't really get him very far at all. And then, just so you have them at this part of the argument, we've made the points we make on distributive justice. You see them there, MS 85 to 86 of the written case. And that then brings me to the final section, which is the claim duty does not run contrary to any jurisprudence concerning liability for the conduct of civil proceedings. The relevant part of our case that deals with this is paragraph 53 onwards, MS 86. So, no dispute that absent malice, opposing parties in civil litigation don't owe a duty to one another. And the point made by my learned friend that those who engage in litigation in good faith are normally protected from being sued in negligence. That principle is derived and cited by the appellant from the four cases there at paras 37 to 41 of their case, De Medina, Crawford, and Willers. Unlike, we say, our facts, where there was a community of interest, a unity of interest in defeating Mr. Ahmed's claim, in each of those cases, there was a true oppositional relationship. They were on opposite sides of the litigation. And of course, the normal rule is no duty is owed. So at paragraph 42 of its case, the appellant argues that the same principle of public policy applies to this case. And he then gives sort of aphorism, a quote, "The law would be in a remarkable state if an unwilling recipient of a claim has a duty to carefully defend in circumstances where someone who brings a meritless claim and makes defamatory statements can do so without incurring any liability, absent malice," i.e. they're acting in good faith. Now, we say, we don't really understand that, and we say that these arguments don't stand up to scrutiny for the reasons that we endeavour to sketch out. The underlying policy justifications, we say, do not apply here, and then we set them out, predominantly from de Medina, summarised at paragraph 39 of Mr. Warnock's case. The inhibition point, concern not to inhibit litigants from invoking the jurisdiction of the court, and then the satellite litigation point, discourage concern about an unacceptable amount of secondary legislation. And then a third policy point, the concern not to inhibit witnesses from freely assisting in the administration of justice. And of course, he's relying there on judgments that were dissenting judgments in both of those cases. The first one, the inhibiting point, we say is not a problem, and it's not a problem for the very simple reason that there's no question in this type of case about bringing a claim, with defending a claim, or rather the Commissioner and the officers are mutually in the position of cooperating together to defend a claim, so that doesn't apply. Then we have the points made about secondary or satellite litigation. We have to accept, inevitably, that the postulated duty may well lead to occasionally some activity in the courts in the right case. Because there's a risk of it's a very questionable argument to say that just because there may be some bad cases, that the courts should knock out the potential for good cases. I mean, that was, we haven't said it out here, but it's etched in my memory. That was Lord Nichols in the Phelps case. I can get you the reference, but I think it's also repeated by Lord Kerr I think in Sagicor. So we say that looking at balancing up the risk of secondary litigation, the first point is a corrective justice point, that given the extent of the injustice, having recourse in the right case and subject to all the controls that exist, that secondary litigation is simply being used to utilise and provide a remedy. It would therefore not be unwarranted. It would be a good thing. I mean, in some ways it reflects the argument that we've had in Michael and Robinson in relation to similar risks that the police will be exposed to attack in relation to some of their operational decisions. Well, it's a good thing that public authorities are going to be held to account in the right circumstances. And now probably for 2 decades, there has been a sort of relaxation of immunities and a march away from fairly unfettered protection of public authorities. And we say, with the greatest respect to Mr. Warnock, that in the private zone of employer-employee relationships, similar principles apply. So if you have a good case, as on the facts, very, very plainly, it would seem prima facie these officers do, subject to the trial process, then they should be allowed to bring their case to court. This is sort of almost an access to justice point. But the second argument, it would not be a collateral attack on a previous decision. And there we quote Lord Toulson in Willers. That's, I won't take you to the passage, it's set out in paragraph 36 of our case. At MS 81. And then Lord Kerr in Crawford at MS 424 is the reference, but set out at paragraph 37 of our case. The need for finality in legal proceedings and to avoid the prolongation of unnecessary disputes must, of course, be considered. Then he refers to, my Lord refers to American jurisprudence. Permitting malicious prosecution claims in civil proceedings would lead to endless litigation seems somewhat fanciful. There is no evidence that this has in fact occurred in those states in America where the tort is recognized. And as Lord Atkin remarked in the King Emperor case, finality is a good thing, but justice is better. Moreover, the evidential difficulties faced by a litigant seeking to establish the ingredients of malicious prosecution will militate strongly against the pursuit of pointless litigation in this field. And there is, we say, there's an analogy with the situation here, and there's no danger of a flood of litigation. We're not seeking to create a new area of legal activity. We are simply, as lawyers, responding to a set of facts where, to use maybe to an extent one of Lord Bingham's slightly more controversial phrases, that every wrong must have a remedy. And I know that's been subject to criticism, particularly by Lord Roger, about it doesn't help us find out or ascertain the nature of the wrong. Then top of page 40, we say built into this is the band of reasonable responses test, and the fact that these are fairly exceptional factors which are unlikely to be repeated where you've got the exoneration followed by the public condemnation. That's a subparagraph B. I think some of the points at 87, or maybe all of the points at 87, I've probably now made. 87.1 I've made, that's the Lord Nichols point. A good thing if it's a good case, and the corrective justice point. Subparagraph 2, in reality, it's an unevidenced floodgates argument. We adopt the analysis of the majority in Willers. Point 3 covered this, reputational damage potentially so serious, justice requires a remedy. And then I referred to this a while ago in a slightly different context, but this is a reiteration of Lord Gough via Lord Bingham in his dissent in the Dee and Berkshire case. To accept as arguable a claim by here employees on facts such as give rise to these appeals involves no massive extension of a prima facie duty. It's not unimportant, for it accommodates what Lord Gough of Cheveley and White and Jones called the strong impulse for practical justice, but in legal terms it is a small analogical incremental development. Inhibition of witnesses is the final section. As to the concern not to inhibit witnesses from assisting in the administration of justice, we say that what we are seeking in this duty does not impinge upon the immunity of things said or done in the face of the court, or to any of the activities sufficiently closely connected to the giving of evidence in court. And the failings that we have set out, I think I set out where you find them yesterday, and they're pithily summarised in the Court of Appeal decision, that none of that is touched by the immunity. Darker is the case where the boundaries or limits of the immunity have been explored. That was a fabrication case. Claims were struck out by the judge on the basis that the impugned acts were within the immunity, and then the House of Lords rejected that contention with Lord Hope setting out the core immunity as extending to anything said or done by them in the ordinary course of any proceedings in a court of justice. The policy being to encourage honest and well-meaning persons to assist justice, even if dishonest and malicious persons may on occasions benefit from the immunity. And then there's a debate about the boundary, how far it will extend. And then some examples were given. Preliminary examination of the witness, including police witnesses when proceedings have only been contemplated, was one. An expert report drafted in the knowledge that if child abuse had been found, proceedings would be brought. Possibly technical reports undertaken by officers with particular expertise, even ultimately when proceedings are not brought. Now, we say our failings, and there in fact you see the reference, did not fall within the immunity. They were not part of a participation in the judicial process by a witness. And we also get assistance from the Singh case in relation to a restrictive approach to the immunity. I don't have that at my fingertips. Is that paragraph 19? There we go. If it's not paragraph 19, we'll find the reference to that.
It is 19, Mr. Bowen.
I'm grateful. And that was read to you yesterday.
Paragraph 90, sorry, where
Singh.
The Singh case.
Singh and Reading.
the same case, yes.
The Lord Justice Lewison case.
Yeah.
So the errors in this case, this is the penultimate paragraph of the Speaker. The errors were failure to identify, preserve, retrieve, or make available important evidence, including expert evidence. And then, in fact, the reference I made to the Court of Appeal is there, located at paragraph 39 of Lord Justice Morbick's judgment. So we say we're on all fours with the type of activity relied upon, or what was going on in Dhaka.
There's a distinction, isn't there? If you look at Dhaka, the issue in Dhaka was related to the investigatory work done by a police officer prior to the commencement of a criminal prosecution. And that's the context of that case, whereas you're saying that the same principles should apply during the conduct of litigation.
Sorry, I just need to locate Dhaka.
I mean, the main judgment is actually given by Lord Hutton, and he starts off his judgment with that proposition. Similarly, Lord Clyde at 1061, the allegation was at D, conspiracy to cause them to be charged with offences which they knew or believed to be false. And it was an attempt to extend the immunity relating to judicial proceedings backwards to the investigatory stage. Now, if you go, Lord Hope is rather more complex examination, and if he's saying something different, I'm not sure he is.
Well, it's the point that we made, that I'm prompted by my learned friend, is 1053, MS 1053.
Yes.
448 C to F. Crucial difference between the statements made by a police officer prior to giving evidence and things said or done in the ordinary course of preparing reports for use in evidence, where the functions that they are performing can be said to be those of witnesses or potential witnesses, as they are related directly to what requires to be done to enable them to give evidence, and their conduct at earlier
stages. No, the distinction is there. The distinction is and their conduct at earlier stages in the case where they're performing their functions as enforcers of the law or as investigators. So it's that to which the privilege attaches, not the whole of the earlier part.
But just reading on, my lord, I think the actions which the police take as law enforcers or as investigators may, of course, become the subject of evidence. It may then be necessary for the police officers concerned to assume the functions of witnesses at the trial to describe what they did or what they heard or what they saw. But there is no good reason on grounds of public policy to extend the immunity which attaches to things said or done by them when they are describing these matters to things done by them, which cannot fairly to be said to form part of their participation in the judicial process as witnesses. And that's the point we've already made. The purpose of the immunity...
Pause. Obviously, this is a case about witnesses, not about parties, but aren't you trying to extend the requirement of, aren't you trying to reduce the immunity so it doesn't apply to things which can be fairly said to form part of, in this case, the Metropolitan Police's participation in the judicial process as parties?
No, I mean, it's quite, I mean, it's a long time ago, but it's reminiscent of arguments that raged in the Hall and Simons litigation about Rondell and Worsley and and whether or not the close connection test, and when to what extent should advocates be immune, and the way the law has developed, as I understand it, and it's reflected here as well, is that they are cutting down, judges have been cutting down the protected zone. And it's the next point. The purpose of the immunity is to protect witnesses against claims made against them for something said or done in the course of giving or preparing to give evidence. That's not this case at all. It is not to be used to shield the police from actions for things done whilst they were acting as law enforcers or investigators.
Well, your complaint is that is not for something they did in the course of preparing to give evidence. It's a complaint about something the Met didn't do by way of preparing to give evidence.
Well, it's they lost stuff. I mean, they lost their pocketbooks. They lost there was a lot of evidence given by Barbara Ahmed, which was said to be entirely inconsistent with what he subsequently said in his witness statements. And that was all given conflicts between what he said and his wife said, for instance, in the disciplinary case that lasted for 3 days. All of the transcripts were lost. It's like the famous speech that Geoffrey Howe made in the House of Commons about Mrs. Thatcher years ago, having his bat broken before he goes into bat. That's how these officers felt, because the material wasn't there. And we say that quite simply cannot be covered by DACA. So, I mean, there it is. I can't really add very much to that. So there's 6 minutes to go. Unless there's anything else, or unless there's a question that's going to come to answer anything difficult that I've been asked.
Actually, there are 8 minutes to go, according to my clock, Mr. Bowen. My lord agrees.
All right.
So think carefully whether there's anything more you'd like to say. Exactly.
We haven't yet, I'm afraid, there's been so much going on here. We haven't yet had a chance to, and if there is anything more we can say, we could put it in by way of a note afterwards to ask the question that your ladyship asked us yesterday about the tort of defamation. It's the point that's made, I think, by Nick McBride towards the back of volume 5, the Cambridge academic, commenting on this case, which I think may have been, it may or may not have been the inspiration behind your ladyship's question.
Well, I have read it.
Defamation.
I have read it, yes.
Yeah. And you'll remember that what he says in that is that the something more, as he put it, in Spring was not mere reputation. It's the point that Lady Justice Hallett made in the Fomersville case, and this is all set out. You'll find, when you go through it, you'll find this is all in our written argument. That mere reputation is defamation territory. The law of tort will come in to compensate in circumstances where, as well as the mere reputational loss, you have something else. The something else in Spring was rendering them unemployable. The something else, according to McBride, is the fact that being labelled as abusive, violent thugs guilty of gratuitous violence against an innocent, compliant man was, in his words, hardly liable to enhance their prospects of promotion in the Metropolitan Police. So That's the McBride point about there being something else. So this case is akin to Spring, and he says that the Supreme Court in this case will have to deal with a very similar question that emerged in Spring. So that's the McBride point. The answer, and it may well be that this isn't at all comprehensive, and forgive me for this, but I yesterday, just off the top of my head, said malicious falsehood. We add to that the emerging tort of misuse of private information that has come as a result of the sort of bridge between Article 8 and the law of breach of confidence, and data protection. The Data Protection Act provides statutory torts for reputational damage. Now that may or may not be enough. If you want more on that, we haven't had time, I'm afraid, to really go into that and give you chapter and verse on it. But if you would like that, and if you would indulge us, we would provide a note, provide it to my learned friend, and give you any help that we can. But
if you think that would be helpful, by all means do.
thank you very much.
Yes.
But, those are my submissions, and I apologise for spending too long on issue 1.
Thank you very much indeed, Mr. Bowen. Mr. Lemar? Well, it seems appropriate for us to adjourn at this point, and we will look forward to hearing your reply at 2:00.